Hello, my name is Andrew Emsley, and today I'm going to give you a brief presentation on the Supreme Court case Marbury versus Madison. Now, to start off this presentation, I'm going to give you a brief background on when and why this case occurred. Now, the case was officially argued on February 11th, 1803, and was decided on Wednesday, February 23rd, 1803. But actually began 2 years earlier, or I should say a little bit less than 2 years earlier, on March 2nd, 1801, when President Adams was replaced by President Jefferson. Now, before Adams was replaced by Jefferson, he had to appoint quite a few people to the position of Justice of the Peace for the D.C. area, including William Marbury. But due to the short time frame, he was unable to send out Marbury's commission alongside a few others before President Jefferson took office. Now, to make matters worse, Jefferson actually ordered his Secretary of State, James Madison, not to deliver the remaining commissions, thus causing Mr. Marbury to sue for his commission. Now, I believe the Supreme Court decided to hear this case, A, because Chief Justice John Marshall was, surprisingly enough, also President Adams' Secretary of State when Marbury was appointed, and because of the Judicial Act I mentioned earlier actually gave them original jurisdiction for this case. Now, in this case, the Supreme Court decided to go against Mr. Marbury and say that he was not allowed to receive his commission. Now, this conclusion came on three rather simple questions. Firstly, does Mr. Marbury have a right to his commission? Secondly, if he does have a right to his commission, and this right has been violated by President Jefferson and Secretary of State James Madison, do the laws of America allow him to get his commission? And thirdly, if the laws of America allow him to get his commission, can the Supreme Court force President Jefferson and James Madison to give him his commission? Now, for the first two, they were like, yes, he does have a right to his commission. But for the third one, they were like, no. And this is because this Constitution says the Supreme Court can only have original jurisdiction in very distinct cases involving ambassadors or other public officials for the United States, or if a case directly involves the state itself. Now, the Judiciary Act of 1789 extended this, which is unconstitutional in the Supreme Court's eyes. Now, surprisingly enough, only 4 out of the 6 justices actually helped create an opinion and decided the case, and it is unknown why 2 of them decided to abstain from helping in the decision-making process. Now, as with this case, it surprisingly only had the majority opinion, and that was written by Chief Justice John Marshall. Now, this case is very important because, as I said earlier, it caused a law to become unconstitutional, and that is what judicial review is basically all about. So it set the precedent of judicial review, but also it set the precedent that the president is not above the law by saying Jefferson's refusal to give Marbury his commission was also illegal. Now, to end off this, here is my bibliography. I really hope you guys like this, and I hope you all have a wonderful day.